Well, thanks. I'm Wolfgang Theil, and as you can see, my title is Systematic Legal Foundations for Monetary Economics. I'm part of a small team of independent researchers from Germany, and we're in the process of founding an academy for new European political economics. As you can see in the title, we are interested in understanding the current situation in Europe through the lens of monetary economics. But, when we started to look more closely at the different theories that economics have to offer to explain financial crises after 2008, we noticed that, there's basically two paradigms. There's the neoclassical paradigm, which Heinsohn talked about and pointed out that this paradigm doesn't really have a place for money. So it's not really a surprise that it doesn't have much to say about financial crises. So right away, we were a little dissatisfied with that kind of approach to economics. So that brought us to the field of Post-Keynesian, Post-Keynesian, I have to say, monetary economics, which was developed in the 1930s in response to the Great Depression, which also started with a stock market crash and then a big banking crisis. We found that in monetary economics, we have better explanations for financial crises, but the situation in Europe and in the Eurozone also present another set of challenges that are more institutional. And monetary economics, from a Keynesian perspective, does not really have an institutional foundation that would allow it to really capture these institutional problems. And our conclusion for that was we need to build an institutional foundation for monetary economics using law. That's the basic idea. And we learned a lot from Gunnar Heinsohn and his approach to property economics, which actually got us started in that direction. But we decided we wanted to go about it a little bit more systematically, not just focusing on property rights and private law, but also take into consideration the legal system as a whole, which also includes public law. We'll get to that in a minute. Now, when we look at the field of monetary economics today, we can see that there's a number of different approaches being discussed, but none of these is really strong enough to really compete with neoclassical economics, because monetary economics lacks a comprehensive and shared paradigm. So, two quotes I'm giving you here by monetary economists themselves who really admit to that. And they say, well, we're having a hard time being heard with our analysis of these crises, because we have a good explanation for financial crises, but we don't have a coherent theory. So neoclassical economics still wins, right? So our goal is now to explore the idea whether we can provide such a paradigm that would integrate the field of monetary economics by using the legal foundations of capitalism to provide that. And this is just to give you an overview of the project that we are working on. We call it New European Political Economics, not just because we want to analyze the crisis of the Eurozone with these categories, but also because it's a theory about European civilization, really, because property rights are the core idea, the core concept of European civilization. And also, from our perspective, the core idea, the idea of law, is built upon it, comes from. So we start with the legal foundations, distinguishing property rights and contract, which is the private law side of the legal system, but then taking into consideration also the state and public law. And right there we can notice there's a contradiction between the basic principles these two types of law are based upon, because property rights and contract are based upon basically freedom, equality, and consent. That means we have free and equal citizens meeting each other on the market and creating legal obligations by contract, that is by consent. Whereas public law works on a principle that's totally in contradiction with that, and that's the principle of command, essentially. The best example would be taxation. You don't get asked, do you want to pay your taxes? We're making you an offer to pay your taxes, and then you can also refuse that offer. Like on a free market, you have to pay your taxes, right? So right there we see these two areas of law being sort of in contradiction. But we're also going to see that we need public law we need a state to guarantee private law. And this contradiction is one that then plays out in history in a sort of swaying between these two poles. And we're right now more on the market side again. In the 30s, what followed was a swing to the state side, as we all know. Roosevelt's New Deal and what happened in Europe after that. Okay, but I want to get to point two. We start with the legal foundations and use accounting and balance sheets to connect the legal sphere to economics. First on a micro level of individual balance sheets, and then sort of creating a model of the economy as a whole as a system of interconnected balance sheets. That's something that's standard in monetary macroeconomics today, and what we are doing really is relating that back to the legal foundations that it is really based upon, that monetary economists just take for granted today. Okay, then on the third level we introduce free citizens as actors. Intentional actors must be part of the model. And the fourth level then, my colleague Nicholas is going to cover a little bit, introduces credit, means of payment, and the banking system. So that's where money as a means of payment comes into play. And points 5 and point 6 we can't cover today. So I'll just move on and go into a little bit more details about legal foundations. This is the map we use to conceptualize our perspective on the spectrum of law and non-law that we can sort of find across the European Union. And of course, in the center, we put property rights here, which is the basic idea of European law, and private law, which is based upon that. And the contradiction I was talking about with public law, we call it dialectic, because there's basically a contradiction between these two, but private law cannot exist without a state and public law. And they're in constant tension with one another, which is then being mediated by constitutional law. And we're going to get into that in a minute. Then we have on both sides of the law, areas of non-law. Essentially, pre-state reciprocity, which means this is basically the area of legal anthropology, looking at social systems that do not have a state, where people cannot rely on contract and don't have to rely on contract for their social relations, but on reciprocity, which is usually based upon kinship, solidarity, and everybody knows that from his own family. So that's probably the best example that you can use to understand what's meant by reciprocity, and I'll leave it at that. The other area of non-law we have here is international law and also EU law. We classify that as non-law because maybe the most important characteristic of law from our perspective is that it must be enforceable through a centralized monopoly of force. If a social rule is not enforceable by a state, it's not law, it's some other kind of social relation. So in international law, we do not have this international state, the government, but we have international so-called law, which is really more like informal reciprocity. So if we want to apply this to Europe, maybe we could say that if we're sort of in the western center of Europe, we're more in this area, and as we move to the southern periphery, we find that in these areas the law is weaker. Sometimes property rights are not really documented. Contracts are not as securely enforceable as here in this area in the western part, and we're moving more into this area. Greece, for example, or southern Italy, Sicily would be examples. So this is the basic map we're using to conceptualize law and non-law, and we're now going to go a step further and connect this to accounting. And here we take inspiration from John R. Commons, who in 1934 wrote a nice book called Institutional Economics. And we're just giving you the most important quote here from our perspective, which is, other sciences deal with things, economics deal with legal rights over things. That means it deals with state enforceable legal titles that are then recorded on balance sheets. And here you can see two types of balance sheets, or two balance sheets with the balance sheet categories that two approaches in monetary economics are using. And you can see here, for example, stock flow consistent models. They put on the asset side financial assets and tangible capital. Now, tangible capital could be misunderstood as being something physical. So we replace this with the precise legal terms, because actually what we're doing here is we're accounting for a property right in a house, for example. If you have a house and you have a tenant, you've rented it to someone else, you're still the owner of the house and you have the asset, you have the monetary value of the house, but the tenant has the physical possession of the house. So what's in the balance sheet is the property right. So financial assets we classify as claims. That means essentially social relations that are enforceable by state, and it can come into existence either by contract or by command, that is by public law. And on the liability side, we replace the term loans with the legal term obligations. And, well, the general classification of assets and liabilities we replace with the legal terms just to make clear that what we're accounting for are really legal titles that are then made comparable through a money of account. Okay, similar for modern monetary theory, but let's skip that. This is just a summary of what we just did. This is the type of balance sheet that we're going to work with within our approach. And I don't have much time left, so I'll skip this too. Well, okay, so Einstein essentially explained this today. We have property owners. They cannot rely on kinship reciprocity anymore. They have to relate to each other by way of contract and private law. And they have property rights as their assets. They also have obligations and claims in their balance sheet, which are created by contract. And a claim against another person is an asset, which adds to my net worth. It's part of my wealth. And an obligation is, of course, debt. I owe something to someone else, and that subtracts from my net worth. So we have here, this side, minus the obligations, is the net worth. Now, if we look at that, we can see right away, private law cannot exist by itself. It needs a state that actually enforces these rights to make them reliable. So we add a state to that model, which of course also has a balance sheet on which it accounts for its assets and liabilities, or rights and obligations. And in order to be able to provide that service of guaranteeing and enforcing law, the state has to tax its citizens. So we find on the right side of the state balance sheet the tax claims, and on the obligation side, on the liability side of the balance sheet of every citizen, we find tax obligations. And this is the basis for the superior creditworthiness of the state, that Heinzmann also pointed out today. So, if we remember this contradiction between private law and public law, and the contradictory principles these two are based on, we see right away that they're in conflict with one another. So, for example, it's the state who has to guarantee the property rights to the citizens, and these are rights of exclusion against everybody else, and the state as well. So the state has to guarantee property rights and freedom against itself. So right there we can see that there's a conflict going on right at the center of the legal system. And that, I think, we will be able to show in more detail later, okay, then plays out in history as a sort of oscillating between the market pole and the state pole of the system. But, well, we first want to not fall into the trap of market or state fundamentalism, which was what people were doing during the Cold War, right? Either you were liberalist or you were socialist. But what we want to do first, from our perspective, is to conceptualize how this contradiction, how this dialectic is mediated in law first. And what we see here is just that these two contradictory principles are then being mediated by constitutional law, by which the citizens themselves become little sovereigns who actually create the public law legislation themselves. So they govern themselves now. And in other words, they can influence legislation about taxation as well, of course. So this is just a little reminder. I won't go into detail about that, because the next thing I think is a little bit more important. And this will be the last thing I show. So we can now see how this dialectic between the public law side and the private law side actually plays out in what the citizens do and how they act within this framework of public law and private law. So this is level 3 of our paradigm. We're now introducing the actors. We got the law, we got the balance sheets as connection to the economics, and we now take a look at what people do once they're placed into this cage of law, as Max Weber called it. And if we look at the balance sheet, we can see then that in the claims category, as well as in the obligations category, there are claims that are claims of private law that originate by contract, and on the obligation side, private obligations that also originate by contract. But also, the red in red print, claims of public law and obligations of public law. Everybody has to pay taxes to the state, right? But most people also have some kind of claims against the state, which are not created by private law, but by public law. And here's a few examples. Subsidies, payments, bailout money for the banks, right? I don't know about that. And Social Security payments would be another. So if citizens look at their balance sheet and want to maximize their net worth down here, which is their economic security, basically, as Heinzmann explained, they have to do two different things. They have to follow two different strategies. As subjects of private law, they need business strategies to optimize this balance here. Property rights plus contractual claims minus private obligations. But if they want to make sure that they get more from the state than they have to pay towards the state, which is something, of course, everybody wants to do. Nobody wants to pay more to the state than get from the state. They have to use political strategies. And this is our way of reintroducing the political side into economics, which today's economics is not really looking at in much detail. So how do citizens do that? We all know that as well. They form associations, such as workers' associations, employers' associations. They try to influence public discourse. They do lobbyism and political rhetoric and propaganda, in which they often use economic theories to portray their own interests as general interests, when in fact they're only interest of a specific segment of the population. So here we can see that a kind of class struggle is played out in this field of optimizing this balance between different groups of the population by way of political rhetoric. And economic theories are part of that. And that may explain in part why economics didn't maybe focus so much on explaining what's really going on, but on serving different interests in the population that may have distorted the perspective of economics somewhat. Thank you.